Good morning, everybody. I hope the weather is better where you are than it is where I am. But anyway, we've got plenty of interesting things to distract us, hopefully, that this morning on this webinar. This is the latest in our free series of in-house lawyers, or IHL forum webinars, and also the latest in a series of webinars that focuses on artificial intelligence and AI and its legal implications. My name, for those who are not familiar with me, is Luke Dixon. I'm a partner working at Freeze, principally working out of the London office, and I head the data and information team at Freeze. I am delighted to be joined this morning with two other members of the data team who are also AI specialists. First of all, Will Richmond-Coggan, who is a partner in the team, and also Mona Schrodel, who is a managing associate in the team. And they both work principally out of the Oxford office. So moving on, I think firstly with a brief agenda as to what we'll be talking about this morning. Jordan, if you can please move aside, thank you. We've got three speakers. We'll be breaking it down into three parts, therefore, and the three parts are as follows. So I'll be starting off and really setting the scene, talking in sort of high-level terms about the EU AI Act as to what it is, when parts of it are coming into force, what the penalties are, etc., what it seeks to do, and generally speaking, what it seeks to regulate. Once I have spoken and I've teed things up, I'll then be moving on to Will, handing over to him, and we'll be drilling down a bit more into certain obligations which the EU AI Act, or let's call it the Act, it's a bit of a mouthful, let's call it the Act. Well, the Act will seek to impose and therefore be relevant potentially to your businesses as well. Finally, the anchor leg, if you like, will be run by Mona. And Mona's going to be addressing an interesting area of AI that quite often people don't think about at the moment, actually, but we think is going to be of increasing significance in the coming years and is coming down the track. And that is AI ethics. So that's particularly something that will also be useful to think about for horizon scanning purposes, and also to enable that your businesses, where it's certainly relevant to them, will be well positioned for the future. Because as I say, that's something that we see as becoming increasingly important and coming down the track in the future. So with that in mind, and that all set up, let's move on to the first slide of my part of the talk. The Act is here, pretty much, but what is it? So we can move on to the next slide, please, Jordan. What is it for? Well, I think it's fair to say that the EU is quite proud of the Act. Certainly, it is trumpeted and described as the first piece of comprehensive regulation legislation on AI in the world. Might be questionable as whether that's actually strictly true, but it's very much at the forefront of it. And it's also part of a wider digital strategy in terms of legislation, which the EU has been rolling out. Now, one of the things I'm going to be saying, or will be a common thread of what I'm talking about in my section, it is actually a piece of sister legislation that's been around for some time, which I think, we're not necessarily grown to love, but anyway, we're grown to be more familiar with, and that's the GDPR. And in a sense, there's a certain degree of framework similarity between the Act and the GDPR, and they're kind of, not siblings and certainly cousins. So one of the things I'll be talking about are certain areas, the way that the Act is set out, that might have echoes of GDPR about it, and therefore help bring it to life a bit for those who are unfamiliar with it. In terms of what it actually seeks to do, it seeks to set out a comprehensive framework for the development, supply, and the use of AI systems in the European Union. And that framework seeks to ensure that the systems are safe and that they respect the fundamental rights and values of the European Union, whilst on the other hand, also supporting innovation. And that's something that the EU is also very keen, increasingly keen to be seen to be fostering and to foster in order to promote growth within the EU. From a very high level, and we'll drill down to this in a bit more detail, but at a very high level initially. It covers, firstly, harmonized rules across all the EU member states for the supply and use of the systems. But also, importantly, I think, particularly for people on this call, it includes extraterritorial provisions as well. So it's not just stuff that's going on within the EU, it's also outside the EU, notwithstanding things like Brexit, etc. There's also the way it works, as you'll see, is kind of got a hierarchy, or as we'll call it, sort of a pyramid of risk types of system, from absolute prohibitions on the highest risk systems at the top of that hierarchy, or that pyramid, sliding down, if you like, to those which are certain systems which are imposing technical requirements on high risk systems, which are those which sort of provide a significant risk of harm. Down to those which are unregulated. If you beside that, if you like, hierarchy of risk, it also applies to entities within the supply chain in relation to AI systems. So as you'll see, it breaks them up into things like operators, and then within that, deployers and providers and so on. And as we'll see, the obligations that it imposes will kind of depend on what you are in terms of that chain. It also sets out rules for things like general purpose AI systems. So those are the ones which can be applied to a number of different tasks. Has transparency requirements around systems that directly interact with people, with human beings. And it's all sort of tied up, obviously, with market surveillance enforcement, which is something I'll be touching on as well. And of course, it's going to be something that will sort of determine sort of risk and understanding of risk for people on this call and their business. But also it seeks to foster things like sandboxes and innovation and so on. So going on to the next slide, we're thinking, okay, what does it catch? What's the scope of the Act? And I think the best place to start firstly is around what it considers to be an AI system. So it's obviously it's crucial for your business to understand whether you fall within the scope of the Act, because this will enable you to determine the extent to which you have to implement obligations or governance of AI within your business, to the extent you use it, deploy it, etc. As to what the Act says AI is, it basically defines it as a machine-based system, which is designed to operate with varying degrees of autonomy, and that it can exhibit an adaptiveness after it's deployed, and that it's basically fed an input and is aimed at an objective, and then it produces or generates an output. And when it does so, it makes certain inferences when it's actually providing the output. And those outputs can be a number of things, and they're sort of named in the Act as including predictions, content, recommendations, decisions. And this output is basically supposed to, or defined as influencing not just the physical world, but also virtual environments. And now when the Act, in setting out this definition, is trying to walk a bit of a line here between, on the one hand, future-proofing against obviously developments in technological developments in this area, but also on the other hand trying to distinguish AI systems away from other technologies. And so recital 12 of the Act is quite helpful in this respect. It says that the definition of the system should be based on key functional characteristics of artificial intelligence. And those key characteristics are things like learning, reasoning, or modeling capabilities. And the recital says that these are the kind of things which distinguish AI from simpler software systems and programming approaches. So that's what AI is for the purposes of the Act. Then let's take a look at the sort of dramatis persona, the chain of people to whom, or entities to whom the Act applies. And this is an area where I think actually the GDPR experience is quite helpful, because you'll remember, no doubt, when GDPR came out and still obviously imposes obligations on controllers and processors, and those obligations might change or differ depending whether you're a controller and a processor. And particularly in the early days, there was not much guidance out there, and it was pretty difficult sometimes to determine whether you were a controller or a processor. Or certainly there was reluctance for people to take on certain roles, and a lot of negotiation around that. And actually, my experience, that hasn't entirely gone away. So from my point of view, bring this to life a bit from the GDPR context, I'm kind of expecting this similar sort of thing to be happening when you make an analysis of who you are and what your obligations are, therefore, in the chain. But in terms of key entities within a supply chain, firstly, the Act talks about a provider, which is a personal organization that develops or arranges the development of the AI, and this could, for example, cover, in your business, you as an employer making available an AI system within your workforce, or maybe if you're out there on the call and you're a public authority, also making the AI system available for use by members of the public. It also is a sort of deployer as well. And in fact, sorry, that was it. The provider is the organization that arranges the development of the system and places it on the market, also under its trademark. So you've got the provider, which is the one that sort of develops and provides it under a trademark and puts it onto the market. The deployer is the entity essentially which uses it. And then it's got a more overarching definition, which is the operator. And the operator can be provider, product manufacturer, deployer, but also importers and distributors. So as I said, I think one of the key takeaways from this bit is that there will be probably some analysis that needs to be done around the supply chain as to who or what you might be, and therefore what your obligations might be under it. One thing that we're certainly looking forward to is guidance around identifying such entities within the chain, just as we got eventually from the ICO, for example, in relation to controls and processes under GDPR. Then the next bit that I think is significant is territorial application. You might be sitting there thinking, this is an EU piece of legislation. We've Brexited. What do I need to worry about it? Well, actually, again, another similarity with GDPR is that it's extraterritorial. So the Act is applicable to providers and deployers of systems which have a place and establishment, or in the EU, or are located in a third country where the output provided by that system is actually used in the EU. So you can be outside, you can be in the UK, but if the output is used in the EU, you're caught territorially by the Act. It also, the obligations provide to providers of systems and GPAI models that have an effect on the EU, either by placing them on the market or putting the system into service in the EU as well. So that's why this is potentially significant to yourselves, in the UK. It's because of that extraterritorial reach. Before we move on to the next slide, there are a couple of exemptions, probably less likely, I think, to be relevant and to apply to the people on this call. But firstly, it's military and defense. Also an exemption around testing for scientific research purposes and development prior to them being placed on the market. But once you're in a real world scenario, that exemption falls away. If you go on to the next slide, please. Sliding down the pyramid of risk, as we call it, or certainly I call it, but it's also been represented as that graphically, as you'll see, around quite often. So I think it's quite a useful way of thinking of it. You've got basically at the top of the pyramid, the different rules apply with different levels of risk, and there are four main risk categories. So the top of the pyramid, the top risk category are prohibited AI practices, and these things are completely banned outright, and they're banned outright because they're deemed to be incompatible with those fundamental values that I talked about earlier. So human dignity, freedom, equality, democracy, rule of law, all that, old-fashioned stuff, but it was actually very important indeed to civil society and humanity. And this also includes things like the right to non-discrimination, data privacy, and the rights of the child. So these are the things which are obviously absolutely sacrosanct, and therefore that the Act seeks to defend the most and protect the most. Examples of such prohibited practices would be subliminal techniques, exploiting vulnerabilities of a person, and also social scoring. So at the top of the pyramid, they're banned outright. You go down to the next level. These things aren't banned outright, but they are quite heavily restricted. And this is probably going to be the area where businesses are going to be looking at the most at to determine what they need to do in terms of their obligations and how to fulfill them. So these are high-risk AI systems, and they're systems that typically form the safety component of, or which are themselves covered, products that are covered by existing product safety legislation. And in terms of identifying this sort of product, or what might fall into this category, you need to go into the annexes to the Act. So Annex 1 sets out some of them, and these are products which are required to undergo a third-party conformity assessment under product safety legislation. And a couple of examples of that would be things like medical devices and toys. So there's some Annex 1 stuff, but there are also certain systems which are relevant to certain areas under Annex 3 of the Act. And just to provide examples of those which fall under that annex, you've got systems which relate to law enforcement, critical infrastructure, certain types of biometrics like ID, categorization, emotion recognition, education and vocational training, and also access to essential services and benefits. So, as I said, this is probably where these aren't banned, but this is where the most onerous obligations are. So these are the kinds of AI systems that people will be focusing on the most, I suspect. Next one down, you've got limited risk AI systems, and these are ones which perform autonomous tasks, which involve direct interaction with the human, or which create content which can be viewed by one. These are systems which maybe provide a specific risk of impersonation or maybe deception, irrespective of whether it's a high-risk AI system or not. And examples of this include things like chatbots, and systems generating deepfakes. And then at the bottom of the pyramid, you've got minimal risk AI systems. These aren't such a concern because they're unregulated. No additional requirements under the Act. Examples of this are things like AI-enabled video games, stuff like spam filters, online shopping, recommendations, maybe appropriate for today, weather forecasting algorithms, translation and grammar checking tools, which would be thankful. I'm sure we'll be relieved about that. And also automated schedulers, stuff that quite merciful, really, stuff that we all rely upon quite often, today in our day-to-day lives. So wrapping that up, you see that the obligations will apply across a chain, but also according to a hierarchy of risk, and also have extraterritorial significance for systems as they are defined. So moving on quickly, so we can get over to Will to drill down further into this. What if we get it wrong? Well, obviously, as you might expect, the Act introduces penalties, and those penalties are quite stringent. In fact, they're more stringent than they were under GDPR potentially. One of the underlying approach to it, which you might be familiar with from GDPR, is that the penalties and the sanctions should be effective, proportionate, and dissuasive. And it introduces fines which are sort of tiered in their approach and sort of relates to the hierarchy of risk which I was talking about. So at the top level for the prohibited stuff, the most serious fines could be the higher of 35 million euros or 7% of total annual worldwide turnover in the preceding financial year. When you're going down to the high risk ones, it's 15 million euros or 3% of that turnover. So those familiar with GDPR will note that actually, it's higher than it is for GDPR, which is either 4% or 2%, depending on what you've done wrong. Then in terms of who's enforcing it, it'll be enforced by a combination of a sort of a centralized approach with a European Commission AI office, and also a decentralized approach into sort of localized national authorities within the member states of the EU. Moving on to the next slide. When does it come into force? Well, actually, the answer is it's already in force in some respects, and it's coming down the track in other respects. So most of the provisions come into play the 2nd of August next year. However, prohibited practices or AI, prohibited AI systems are already banned. They were banned in February. Uh, and also there are obligations around AI literacy for people, for organizations who are affected by the Act. And they're also in place now too. And I think Will's going to be touching on AI literacy in due course. As to the penalties, or obviously the juicy bit, they come into play at the start of August of this year. And the rules on the high-risk AI systems incorporated within the products, which are covered by certain product safety legislation, will kick in from August of 2027. So I think the key takeaway here is, in some respects, it's already upon us, and in other respects, it's just coming quite soon down the track. So if you're one of those, organizations that, when we set out, I think our poll a while back around this AI series said, yes, we're thinking of doing it, or we're doing it, or about to do it. This is an example of how now actually really is time for the organisation, if it hasn't done so, to engage with the legislation and work out whether it's in scope and then what it needs to do. On that note of what it needs to do, I want to thank you for your time listening to me, and I'll pass on to Will, who'll give you a drill down into the obligations under the Act.
Thank you, Lee. And good morning, everyone. So, yeah, the question, of course, is why does this matter to my business? And Luke has already touched on this to some extent. Just before I start, and speaking of questions, there is a Q&A slot. Okay, let me try and do that. Is that any better? Someone's just said I'm a bit muffled, but hopefully you can hear me now. So yeah, there's a button at the bottom which says Q&A. If anyone's got any questions during the course of this presentation, do please post them on the Q&A button, and then we will try and leave some time at the end to just sort of pick up at least some of those, and we'll come back to it on individually that we're not able to answer during the course of the session. So if we move on to the next slide, we can see, as Luke has already touched on at a sort of quite high level, all the different ways in which you might be caught by this and why it might matter to you, even if your business is primarily based outside of the EU. The obvious ones are, as Luke's mentioned, if you've got an establishment in the EU, which broadly means sort of offices, but you might have sort of warehouse facilities over there. You might have some sort of outsourced function where staff or contractors are based in the EU, even if you don't have a sort of permanent physical presence. Equally, even if you're an exclusively UK-based business, you might well have customers in the EU, so you might be providing physical products with AI built into them. You might be providing online products and services that have an AI component. And if those are being accessed by individuals in the EU and they're going to have an impact on them, then that brings them within scope in the way that Luke has described. And I think also it's worth bearing in mind, you yourself and your business might be exclusively UK focused, or you might have customers in other territories around the world, but you might be using suppliers who are based in the EU. And part of your due diligence and risk assessment, therefore, ought to also be to look at how your suppliers down your supply chain are complying. If they use AI in components which they use to deliver services to you or to help you with fulfillment or something like that, you're going to need to look at, how are they acknowledging or recognizing what sort of risks are presented by their use of AI, and does that expose you to any risk? Because often when you've got sort of people further down the supply chain, there is an imbalance we're seeing in the way in which risk is allocated between those suppliers in the background and the company whose branding is all over the product or service that's being delivered, which may well be yourselves, and potentially finding that you might be exposed to significant sort of adverse consequences for having put your customers' information at risk or expose them to sort of harm because of something your supplier is doing. But your supplier will have some sort of indemnity provision in their contract, which says that they're not liable beyond maybe the cost of the contract to you, and you end up sort of carrying the can in those circumstances. So obviously far from ideal, and I mean, we always advocate in relation to sort of data and GDPR, making sure that you've done good due diligence on your processors and sub processors. But this is another aspect to that supply chain due diligence, which we would very strongly recommend you to be thinking about. Now, in a sense, we sort of jumped ahead, but if we move to the next slide, I'll spend a bit of time now just talking you through if you are in any of those circumstances, what sort of things should you be thinking about? And again, very much as Lucas said, we're not completely reinventing the wheel here. A lot of what is needed under an AI risk assessment is similar to what you might have been doing already in a data protection impact assessment, for example, where you're deploying some sort of sophisticated piece of technology which impacts data in an unusual way. And parenthetically, I will say, of course, if you are deploying AI within your system, don't forget that if it's handling personal data, you're probably going to want to do a DPAA as well as everything that we're recommending here in relation to the compliance with the AI Act. But the first step, as with an impact assessment, is to think about risk. And like the GDPR, this is a risk-based piece of legislation. It's looking at those things which are most dangerous and and putting in place what are supposed to be sort of proportionate constraints around that, depending on the level of risk that you identify. Now, you can be guided and you should be guided by that pyramid as a starting point. And I would say, even if you are not caught by the act at all, there are probably some things at the very top of that pyramid which you just shouldn't be doing, because the reason why they're banned in Europe is because of the very severe impacts that they might have. And certainly, if you are using anything like that, like sort of social profiling, social credit systems, things which are doing inferences around sentiment, live facial recognition, you absolutely shouldn't be doing those without good advice on exactly how you navigate the regulatory frameworks that do apply to that, even in the UK, even without the AI Act being applicable. But let's think about the development and deployment of tools that are going to be used in the EU. Thinking through the risk means that you've got to understand, first of all, exactly what your system is meant to do, but also what it's capable of doing. And those things are not always the same. Indeed, what we're increasingly finding with AI systems is that they are capable of being put to a range of uses which are far beyond what the intended purpose of them is when they're deployed. And that can be things as simple as chatbots, which are then used by bad actors to create defamatory content or content which is unlawful. And the same with image and video generating devices. If you've got systems which are going to be doing a degree of automated decision making, you need to be really sure that those decisions are going to be made in a way that's fair and appropriate to the people that are affected by it. So an obvious thing to think about is the extent to which there are risks around bias and decisions that disproportionately are unfavorable towards people of particular socioeconomic backgrounds, people of different cultures, or whether it's gender imbalance or something of that sort. Now, when you have identified conceptually what the risks might be, and of course there's going to be a whole array of others which will vary very much depending on the nature of the tool that you're putting into play or that you're adopting. There is another step between that and actually putting in place safeguards, and that is to quantify, how much that conceptual risk actually is manifested in real life. Now, for that, again, depending on the complexity of the system and how much resource you've got available to devote to this, we would very much recommend doing some sort of red teaming exercise where you're actually looking at a test deployment of the system where you have people that work to try and break it, that they actually try to see how can we misuse this, how can we make it produce unintended consequences, and that they're actually incentivized to do that, because the more you can flush out of the problems with the system, during that red teaming exercise, during that sort of early stage pre-deployment, the better your safeguards are going to be when you actually come to deploy, and the greater the chance that you're going to manage appropriately the risks that that system might expose you to. Now, when you do that red teaming, what you might find is actually, delightfully, the people who've developed it in the background have done a really good job of building in, as they should have done, safeguards by design from the early stages. And that try as you might, you can't make it produce unwanted consequences, inaccurate information, damaging responses, disgorging personal data of others, and those sorts of things. But you need to have tested it, and you need to be confident, as confident as you can be that that's the case. With all of these steps, it's really important that you're documenting them as you go along, because if there is a challenge, and it will be a challenge primarily that comes through supervisory authorities in individual countries within Europe, where someone makes a complaint to that supervisory authority, they will require you to be able to demonstrate, much as with the accountability principle under GDPR, what steps you have taken to discharge your obligations around the assessment and management of risk. Now, I've put in the notes that there may be risks which, even though we're not on the top tier of the pyramid, you as a business nonetheless regard as unacceptable. And if that is the case, and those can't be managed in a suitable way, the prudent thing to do will be not to go ahead with the deployment of that system. That means that you need to be doing this assessment not 2 or 3 days before the system goes live, but in the early part of any sort of project to deploy. And if you're involved in the development of the systems, it should be something that you're doing iteratively from the earliest sort of alpha stage prototypes of the product, and you should keep doing with each sort of iterative sort of generation of the tool or the model that you're using. Let's assume that you've assessed the risk, that you've put in place safeguards. And again, I'm not going to sort of talk a lot about the specific safeguards now, but there are a range of safeguards that can be put in place for many of these risks once you identify them, and you should be working with your developers and your advisors to make sure that those are put in place and that they're suitably robust, retesting and so forth. Once you've got all of that, you're satisfied that you've got suitable safeguards in place, you've got a system which you're ready to go live with. The other step, which is really important, and this applies even to those sort of moderate risk, or anything really above the sort of low to no risk models, is you've got to make sure that you're being suitably transparent about your use of these tools. And we would suggest, again, that that's in two parts. Part of it is a little bit like the privacy notice. If it's handling personal data, your privacy notice needs to talk about the AI you're using, but you should probably have some sort of explanatory document which tells users, this is what the AI is meant to do, this is how it's intended to work, here are the limitations with it. And that can be part of your safeguards. An element of the safeguards that you have can be that you give a health warning to your users that says, do not rely on the outputs. This tool is provided for general information only, but anything that is produced might be inaccurate and should be double checked before you act on it. That can be a part of your safeguards, and it can also be a part of your transparency exercise. The other area for transparency is just to be really clear about, what decisions are being made where there's human oversight, what decisions are being made entirely autonomously. And again, that can have implications for your obligations under GDPR. It can have implications in other areas. But it's just, people will want to know this. And, it's much better to be able, if someone does make a complaint, to be able to point to something which drew their attention very clearly before they started inputting their data, before they started engaging with the system, drew their attention very clearly to the fact that there was going to be a degree of automated decision making that goes on in relation to that. Now, I want to leave enough time for Mona to talk about the sort of broader ethical points which do overlap with some of what I've been talking about already. Um, so I will move on, I think, to the next slide. And that is just that I want to, um, yeah, just highlight very quickly here some of the points for the high risk systems specifically. And I'm going to just take this through quite quickly. Again, the strong recommendation would be that if you're doing a high risk system, the challenges around that are going to be quite bespoke, are going to be quite in depth, and needs to be thought about quite carefully. But understand that the legislation requires you not only to have built a system with guardrails, but to have in place in the background systems that can assess and mitigate the risk. So it's not just enough to do a one-stop shop assessment before you deploy. You've got to actually have monitoring systems which are running in parallel with your AI and that are actually looking at and mitigating risk in real time as much as you can. Where we've thought about discrimination, and I've mentioned earlier about sort of guarding against that, you've got to be able to show that you've actually put in place in your data collection suitable controls to make sure that the data that's collected is high quality and that it's suitably representative to minimize the risk of discrimination. You need, it sort of follows naturally from what I've been saying already, you need to have the ability to log faults and trace errors so that you can't just have a black box and say if something goes wrong, well, we don't know, it's just the machine. We don't really have an explanation for that. You need, as I've already talked about, to have detailed documentation so that if someone wants to challenge your compliance, you can demonstrate it. If you're developing systems, you need to make sure that you're giving information to the deployers, which is sufficiently clear so that they can deploy it in a safe way. And if you're the one deploying the system, it follows that your developer should be supporting you with that level of information and guiding you through how to deploy it in a way which is safe and suitable. You need to make sure, and we'll come back to this point in a minute, that you've got appropriate human oversight, and that means that the oversight is by people who understand the systems and what they do. And like all technology, you've got to make sure that it's robust, cyber secure, and accurate. Now, if we very quickly look at the next slide, we can see how in practice these high risk systems work. Luke talked already about the need for some systems to have a certificate of conformity. I'm not necessarily going to go into this in a lot of detail, but you'll get these slides afterwards. And this is from the EU's AI office anyway, where there's a lot more detailed guidance on how you go about that. But note in particular that the conformity assessment must happen before it goes live. It must be registered in an EU database, and there must be a declaration of conformity, and only then can it be placed on the market. And then, if there are significant changes during the life cycle of the AI system, then you have to go back around and do a further conformity assessment and get a further registration and declaration of conformity before those changes are deployed live. So there is quite a rigorous and quite an exposed process that needs to be gone through if you're looking at these particularly high risk AI systems and deploying them. In that high risk context, what I'm going to say next is particularly important, but actually AI literacy, which is what's covered by the next slide, and my last slide, is something which is important for people deploying any sort of AI system. Note some important points which I've highlighted and put in bold in these extracts from Article 356 of the AI Act, which is the definition of literacy, and from Article 4, which is the obligation about literacy. So if we look at Article 4 first, providers and deployers of AI systems are required to take measures to make sure that not only their staff, but also other people dealing with the operation and use of AI systems on their behalf have a sufficient level of AI literacy. So that means it's not only your own people who you need to make sure are suitably trained and knowledgeable about AI, but also you need to audit the capabilities of your suppliers who might be providing outsourced systems which depend on AI on your behalf. Now, when you do so, you need to think about the technical knowledge, experience, education, and training of your staff and those other people, but you also need to think about the context of the AI systems, how they're going to be used, and the people they're going to be used by. So your level of required literacy of your staff will be significantly higher if you are exposing your AI to the public at large and where the implications of their use of that AI are potentially harmful to them. By contrast, if you're making available an AI tool to a very sophisticated technical user who is going to perhaps, reincorporate that AI tool into a product that they themselves are developing, the expectations around your AI literacy will be lower, because you can assume a greater level of sophistication in the developer and deployer of that technology down the line. But what is AI literacy? Well, that's what Article 356 describes. It's about skills, knowledge, and understanding which allow you to make an informed deployment of AI systems and to have an awareness of opportunities and risks of AI and the possible harm it can cause. That is more than simply getting a sort of 1 hour training video about what is AI at a sort of noddy level. That might be good enough for some parts of your business, but in all likelihood, what you're going to need to be able to demonstrate is that those who have hands-on responsibility for developing, configuring, deploying AI really understand the potential opportunities that it presents, but also the risks that it presents and the harm that it can be done. And that when decisions are being made about assessing that risk and implementing safeguards and so forth, that all of that is being done in an informed way by people who actually have the requisite level of technical capability to make those assessments. Now, that might require certification. It might require a more comprehensive set of training activities. Your mileage will vary depending on the nature of the deployment and the tools that you're using. But that AI literacy obligation, as Luke has already pointed out, is in force already. So if any of you touch the EU in any way at all and already have AI live systems, you are already subject to that obligation of literacy in relation to those systems, and you should be making sure that you've properly documented the qualifications of the people that are using it and configuring it, and their ability to assess and understand the threats that it presents. And with that, I'm going to hand over to Mona, who's going to talk about some of those challenges around the harms that AI can do and the ethical component of it, and then hopefully leave us with a few minutes for questions at the end. I'll hand over to Mona.
I'll try my best. So I think we can go straight on to the next slide. I'm going to take a slightly weird route to explain the ethical components today. So bear with me. It all matters, but it will seem to you like I'm going completely off track. One of the things that we find when we talk to in-house lawyers a lot is that they're just presented with somebody else in the business having said, oh, I bought this AI tool, we're rolling it out tomorrow. And nobody seems to care that greater care has to be taken in order to roll it out, what is needed. It's just that AI is sexy at the moment. Everybody wants it. Everybody thinks they need it in order to stay competitive. So they say, well, let's just get on with it. I don't care. Let's just roll it out. Let's use it. So with that in mind, I have picked a couple of stories that aren't necessarily AI related, but I think hammer home the point that it does matter. It does matter to think about what you're doing. It matters that you're not just box ticking, but you're looking at the wider picture. So the first thing I'm talking about is on the next slide, and that is syphilis, which I'm sure hasn't come up in another AI talk you've done before. Now, the reason I'm talking about syphilis is because back in 1932, the US Health Board decided that they wanted to do a bit of a study into syphilis. And they picked a minority group. They picked 600 Black men from a deprived area 400 roughly of whom had syphilis and 200 of whom didn't have it. In 1932, they didn't have an effective treatment for syphilis. So starting out, that wasn't necessarily a terrible idea to look at what are the long-term effects of syphilis, what can we do, how do the treatments we have at the moment help. And they rolled this out. The uptake or the consistency of people showing up for all the tests wasn't that great. So they actually introduced drivers to take them to the appointments. They gave them meals. They promised them that if they died during the study, they would have their funeral expenses paid. They made it really attractive to go to this. Now, importantly, they were telling the participants that they were trying to heal them. That wasn't the case. They were giving them treatment, but it was lower than what they knew was going to help. Not only that, they were telling the local doctors that if any of the participants came to seek treatment, they shouldn't give it to them because they were part of this study. And what they wanted to know, what was the long-term effect of not treating syphilis? So this went so far that in 1941, there was a big army recruitment for the Second World War. And as part of the recruitment process, the medical examination would have found out that these men had syphilis and could be treated. So the US Health Board actually took the step of excusing them from army service and covered up the fact that they weren't really treating them. Fast forward 2 years, in 1943, it was widely accepted that the treatment for syphilis was penicillin, and that was very effective and was going to heal all these 400 gentlemen who were actually infected with syphilis. In 1964, the World Health Organization passed a guidance to say no experiments on humans should be carried out. And that was part of, the fallout from the Second World War. In 1965, the US Health Board thought about that and said, it's too late to treat them now. Look, we've already gone so long without treating them. It doesn't matter. Let's just continue what we've done. And then it only came to light that they had continued the study despite effective treatment being available in 1972 when there was a whistleblower. So that resulted 2 years later in an act in America that banned research that involved humans without properly telling them, and that was exposing them to risk when there was a known remedy. More importantly, though, I think on this is that the mortality rate of Black men after this came to light increased, and their lifespan decreased by 1.4 years by average. And that's because they lost all faith in going to the doctors and trust in the system. Now, the second one I want to talk about, I don't have a slide for because I only came across it 2 days ago, and that is the Titanic. And we all know about the Titanic, and we all know that there weren't enough lifeboats. And perhaps like me, you all assume that that was because they were careless. They just thought, oh, let's not bother with it. It's going to clutter up the decks and let's not have them. The truth actually is that White Star Liner was going to have 3 times as many lifeboats because they anticipated that there would be a new regulation coming in. But then they spoke to the government department and they said, no, we're not introducing that right now. So instead of 64 planned lifeboats, they stuck with the 20 that they were obligated to have. And I mean, we all know how badly wrong that went and how that decision wasn't the right one. So that sort of sets the scene for, I hope, the thing that where you can get away with something because there are no real rules against it, but it turns out it's the wrong thing. And if you, your company, get implicated and you end up being the Titanic, it's going to be a big deal, even if you haven't technically done anything wrong. So we'll go on to the next slide. And that is the hidden risks, I think, that we need to think about. For the syphilis study, it was the minority impact. They picked a group of people who they knew would be tempted by the easy promises of, oh, we'll give you a hot meal, we pay your funeral expenses. For these Black men, that was a proper big deal because it was during the Great Depression that they all signed up. And maybe sometimes when something seems to be too good to be true, it is. So the minority impact, I think, in relation to AI, I don't think we can quite understand it yet because it will only evolve. But for example, elderly people, will they have the necessary AI literacy to understand that they're talking to a machine, what they might need to do to escalate it in a different way? Children, or even people who, because of their economic circumstances, might be more vulnerable to agreeing to do something with AI than somebody who wouldn't otherwise be. Then the next slide, the other hidden risk that I think there is what is below the surface, and that is the Titanic example. You know, you only see the little tip of the iceberg, but there's a lot of it hidden underneath the water that you can't see. You or your company gets the AI tool, it's hailed as being really super helpful and doing wonderful things, but what nobody thinks about is, how was it developed? Was it ethically developed? Or did they, in this way of developing it, were they perhaps using groups of people who are particularly vulnerable or cheap labor to train it up? Where does the data go when it enters the AI system? Does it leave your server? Does it go to the people who developed the system? Is that in America? Is that somewhere else in the world? And these are all questions that are often overlooked or thought, oh, it doesn't matter. You know, now that the product is here, it doesn't matter how it was made. We're going to use it ethically now. But I think there is a sensible way of sort of saying, well, I'm not going to take it for granted. I'm not going to just assume it's okay. I want to know a bit more about how it works, where it goes. And I think that feeds into Will's point about AI literacy. And it's even a little bit more, it's understanding the ecosystem. I'll go on to my next point because I know we want to take some questions as well. My next point is on the next slide. That's horses for courses. Do we actually need AI to solve the problem? Because it's so sexy at the moment, everybody wants to have it. But a lot of the times, there is a solution that is perfectly capable of working or being developed that doesn't necessarily include AI. And it's just something to bear in mind. And I know that's a hard sell in a company where someone says, no, we must have AI. This tool is going to be amazing. But I think there could well be criticism later if it goes horribly wrong and it was just a gimmick rather than an actual necessity. So my next slide is leaning into the red teaming exercise that Will was mentioning earlier. It's the litmus test, try and try again. And for me, a lot of the time when I use chatbots or something, I find it extremely frustrating. They don't understand what I mean, and it's actually not helpful at all. So I would encourage everyone within their company, if you are using AI systems, not just to test it before, but once it's rolled out, to keep trying it out, to say, can someone actually ask our chatbot something that a customer would ask, and see what the result is? Because it's not always everything it's cracked up to be. And unless you test it yourself, you will never understand where the faults lie, that perhaps it's not as easily accessible as it first appears. And let's have another slide because I'm conscious of time. The moral of the story is very much do the right thing, even if the regulations don't ask it of you. I think we've all seen with Donald Trump that regulations can change very quickly. One of the first things he did when he came into power was to rip up or what the US had actually decided they were going to do on responsible AI. And so just because there might not be a regulation doesn't mean you shouldn't start thinking about it anyway. And the EU AI Act is very helpful, I think, in setting a good standard for what you should be thinking about, for what might make a difference, and so on. It's not the be all and end all, I think, because every situation is different. But even if you're not covered by the EU AI Act, I think it's extremely useful to have a document that has thought about these things and has jotted some of it down. Now, we've got 5 minutes left, so I'm going to draw to a close on this. But if anybody wants to just, chat AI-related stuff with any three of us, we're obviously more than happy to do so.
Thank you so much, Mona. Thank you, Will. Excellent and very helpful presentations. We do have 5 minutes and therefore time for a couple of questions. I can see from the chat, we've got one, Will, that you would like to answer, and I'm sure this is one very practical use for organizations in terms of how they actually organize themselves and govern this sort of thing internally. And that's, which department within the company informs the rest? Compliance, legal, IT, HR? Should it be a sub-part of policy, for example, GDPR or data governance?
Yeah, and I think without resorting to the sort of traditional lawyer's answer of it depends, it's really important to think about where your
You're
AI
muffled
system
again.
is being. Sorry.
Sorry.
It's really important to think about where your AI system is being deployed. So, for example, if you're primarily using it to manage data about your own workforce, it's going to be really important for HR to be closely connected with it. But the reality is that most AI deployments span a multitude of the traditional sort of departmental sort of silos, and you need to be thinking about it in a joined up way. It doesn't much matter who takes the lead of it. I would suggest that you probably want someone who's sort of strongly immersed in the technological sort of aspects of the business. So someone like the CIO or the CTO. But it doesn't really matter so long as whoever is taking the lead on it is making sure that they're drawing the right people in from all of the different departments that the AI use touches, and that includes legal, it includes compliance, it might include HR, privacy, but there may also be commercial implications. You need to make sure that the business is approaching AI in a joined up, holistic way, and not just sort of parking it within a single silo.
Great, thank you. There are a couple of questions that I'd sort of like to lead on. And they're kind of connected, actually. They're sort of around that kind of extraterritoriality. One is app uses AI, it was only available to US citizens, but somebody from the US goes into Europe. Alternatively, what if you've got a disclaimer saying it's only intended for use in the UK, but it's also potentially available to online EU-based users? And I think this is quite interesting. There's a narrow point to this, and possibly a wider point as well to this one. I think as to, is it caught by use or is it caught by intent to use? And actually, there's something of a conflict, a little bit, or disjunct in the legislation, because the recitals talk sort of about intent to use, but the actual kind of black letter of the operative provisions talk about the output being used. So in one level, you could say, well, the examples I've just talked about, there wasn't necessarily an intention for it to be used within the EU, therefore is it caught? But on the other hand, factors it is being used. So, on the other hand, there is the argument that it is. And I think probably we would welcome sort of guidance around that typical issue as to that disjunct as to how you're supposed to interpret it. But typically as a lawyer, you interpret the legislation in line with the recitals. And so you might say, well, actually, in this case, it's not necessarily the intent to use there. So is it arguably captured? And probably in the example examples we've got there, they're ones also taking a risk-based approach where actually the exposure is going to be pretty low. One thing, and this actually also touches on something that Mona mentioned, is just interested as to what we think about the Act, because it's rather like GDPR in the sense that I think the GDPR sort of became a bit of an internationalized gold standard, particularly for international bodies that were trying to work out what kind of level of compliance they should apply across their organizations. And to the extent to which, regardless of whether it's EU citizen in EU on holiday or does it not apply, the extent to which, the EU's got that similar aspiration for this. And as Mona said, this represents what you should be doing. Maybe you've got to comply with the EU AI Act in Europe. Maybe you apply the same kind of level of compliance elsewhere as well. You'll end up doing it anyway. I don't know if anybody else wants to pick up one more question.
I'll just quickly, there's a question about what should be top priorities for in-house legal teams in adopting AI. I mean, we've sort of talked a little bit about some of those in terms of the sort of due diligence that you would need to do and the assessments of risk. I think particularly when you're thinking about partnering with external vendors, it's really important that you are subjecting those vendors to informed and quite detailed scrutiny. There's a real danger in this area of being sort of blinded with science, or with the vendors sort of effectively giving you the sense that it's all a bit too magical and a bit too complicated for you to understand. And often that's not true. But it might be a mask for them not really feeling comfortable being able to answer your questions about what guardrails have they put in place, or how have they engineered this to be sort of secure by design. And I think, if you within your organization don't feel that there's someone qualified to ask those questions in a suitably searching and sort of expert way, think about bringing in some sort of external consultant, whether that's a lawyer or a technical specialist, but someone who's going to be able to ask authoritatively those sort of questions and then give you a reassurance that the answers actually do stack up. Mona, you're nodding. Did you have something to add on that? Or?
No, I was also saying is that I think the risk assessment before it's deployed, I think the top priority is to get hold of this technology. Well, ask all the right questions, but also get hold of it before and have a period of time where you trial it out.
And I think that also goes for making an assessment about how good the quality of the data set is, which is just tying into another question that's been asked. You won't necessarily be able to make a direct assessment of the data set itself, but you need to be able to be satisfied by your supplier about how the steps they've taken to assess. And really, the quality, it's a very difficult thing. There's no sort of absolutes, and the EU AI office's guidance on this doesn't give any sort of absolutes, but what they do say is, it's got to be assessed contextually. If you're looking at things that are going to be doing live health monitoring and making alerts if people are in endangering situations, you need to have trained that AI on a set of data which can confidently predict when those people are in that danger, because otherwise, if signs are missed, lives could be lost. You can't get much more serious than that. By contrast, if you're trying to get something which produces a sort of fun chatbot that impersonates celebrities, if it gets it a bit wrong, then that's probably not the end of the world. The quality of the data set that's trained on probably doesn't need to be terribly sophisticated or impressive.
And I think leading on from that, I mean, we've been talking about the Act specifically, EU Act today, but also, and I know that we haven't legislated specifically for AI as yet in this country, but that may well be coming at some point. But it's not to say that we don't already have a framework of legislation that fixes onto things like sufficiency, accuracy, and adequacy of data, because that is what UK GDPR does. So again, it's the kind of thing to be mindful of, and similar kind of considerations come into play. Well, we're past the hour, past noon. I just want to say thank you very much to my co-panelists for the contribution, and thank you particularly to our audience. It's been a real pleasure presenting to you, and we hope that's been helpful. Hopefully we can connect up and talk more about AI and other matters in due course. But in the meantime, have a great afternoon, everyone.
Thanks, everyone. Bye.
Bye.